Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant, let me know when you get started. I'm keeping the time and keep you apprised of the passage of it. And when you're reaching that rebuttal time, if any is reserved. We've read the briefs. We're ready to see when you are.
Good morning, Your Honors. Good morning, Counsel. My name is Emily White. I'm an attorney with the Dan Law Firm. I'm here on behalf of Appellant Valerie Barth. Your Honors, in a foreclosure case, the bank or the folks that are attempting to foreclose bear both the burden of proof and the burden of production on 5 elements. First, they have to show that there is a promissory note. They have to show that they are the assignee of the mortgage. If either the promissory note or the mortgage were first made out to a party other than the party seeking to foreclose, they have to show it's been effectively transferred to them. They must also show that there has been a default in the terms of the note, that they're entitled to foreclose, and the amount owed. And this is a case that went to trial. And at trial, the appellee failed to meet its burden of proof with respect to at least 3 of those elements. And we have assigned 2 errors in this case. First, we believe that the trial court erred in admitting and relying upon hearsay evidence, in particular business records produced by prior servicers. And number 2, we believe that the trial court erred in finding that an endorsement contained on an allonge need not be affixed to that instrument in order to effectively endorse the instrument. So with respect to our first assignment of error, in this case, all evidence at trial was presented through the testimony of a man named Eric Wheeler, who worked for Saline Finance, which was a servicer for the plaintiff only as of 2014. There were 2 prior servicers, City Mortgage and another company called Carrington. And in order to show default and amount owed, appellee introduced all of this evidence through payment records that it introduced through Mr. Wheeler. Mr. Wheeler testified generically at the very beginning of the case in chief of the appellee that he was familiar with plaintiff's business records, that he was familiar with plaintiff's record-keeping practices. All of the qualifications and all of the foundation was presented in terms of plaintiff. But whenever we got to cross-examination, he admitted for each particular record that he was actually not familiar with the business record or business-keeping practices of the prior servicers, including City Mortgage and including Carrington. Those were critical pieces of evidence relied on by appellee in its case in chief. And in this case, we had a witness who simply did not have personal knowledge sufficient to lay a proper foundation for its admissibility. I would like to direct the court's attention to the plain language of 8036, which is the business records exception to hearsay. It says that hearsay, evidence that would otherwise be hearsay, may be admitted if it is a memorandum report, data compilation of events made at or near the time, transmitted by a person with knowledge, if kept in the regularly conducted business activity. It was the regular practice of that business to make those records, all as shown by the testimony of a custodian or other qualified witness. I'd like to highlight that all as shown. All as shown qualifies every element of the foundation necessary to admit a business record. So in addition to the basic requirement of authentication, a witness must say this record is what I say it is. Whenever you're attempting to introduce business records, it's not simply enough to say this is a business record. The foundation must include from a person with personal knowledge that the records were made at or near the time by a person with knowledge that was the regular practice of that business to keep such records. And in this case, the sole witness who was attempting to introduce this hearsay evidence that was in fact relied upon by the trial court in finding that there was a default and in finding the amount owed were business records that were created by 2 prior servicers that this witness candidly admitted on cross-examination he had no knowledge of. And in our brief, we have included pinpoint sites to the transcript, but some of his testimony was, are you familiar with the business record keeping practices of Wells Fargo, the party that produced records? No, I do not work for them. I do not know what their policies or actual procedures are. And for City Mortgage, repeatedly, over and over again, the question, Do you have working knowledge regarding the record-keeping practices with regard to the production of that portion of the exhibit that was created by City Mortgage? Answer, no, sir.
Was he familiar with what the document was?
He said it was a payment record, but he was not able to testify how that document was produced, who produced it, what policies it was produced by, all of those foundation things that we would need in order to establish that this was an admissible business record.
Was he familiar with keeping those types of records, similar records in his role with his company?
Well, let me back up and describe his role a little bit. He testified about his role. He said that his job duty was to testify. Period. He is a professional testifier that travels around the country. He reviews records in order to testify, and then he goes to court and he reads those records. And in this case, he said that he first viewed these records.
No background in the business?
If he had a background, none of that was provided at court. So, and like I said, on cross-examination, he was very specific about his knowledge of those particular records. He said he had no knowledge. I would like to direct the court to a few additional authorities that I apologize that I omitted from my brief. There's actually extensive.
Wait,
yes.
before we take that.
Sure.
Because the other side can only respond to those authorities that are in your brief, in oral argument, you're only permitted to refer to those authorities that are in your brief unless a motion and submission of supplemental authority has been proffered.
Thank you, Your Honor. I will refer then to an authority that is in Appleby's brief instead. So State v. Vrona, and there are many cases concerning 8036 and what it means to be either a records custodian or an other qualified witness. We understand that they are arguing that Mr. Wheeler was an otherwise qualified witness. But the authority is clear that you can have somebody who is not an employee or a records custodian, that's not their job, and they can still testify, but they must show that they're familiar with how those records are actually made, how they are kept, and all of that. And Mr. Wheeler is quite honest. He worked for Saline Financial. He knew nothing more than Saline Financial's own record-keeping practices. The fact that these records were not even incorporated into Saline, in other words, they were not entered into Saline's own computer record-keeping system, suggests that these are two different record-keeping systems. And for that reason, he was not the appropriate witness to introduce those records. I believe they are inadmissible under the hearsay exception. They should not have been relied on it. And without that evidence, the appellee failed to meet its burden of proof and production to show that there had been a default or the amount owed. I would like to now move on to our second assignment of error, that the court erred in finding that an endorsement contained on a launch need not be affixed to the instrument. So in this case, there was an endorsement contained on a launch. That endorsement endorsed it over to appellee, so this is a critical piece of evidence to show that the appellee has the right to foreclose. And it was on a document that was paper clipped together, so a loose collection of papers that is paper clipped together. In Ohio, commercial paper negotiable instruments are special items, and they're transferred in specific ways. The only way that a negotiable instrument can be enforced is that it be endorsed or it's to the maker, and it's held by the party that's seeking to enforce it. Now, in Ohio, the rule says, and this is true of the UCC across the land, that if you have an endorsement that's contained on something other than the instrument, you can have a thing called an allonge, another piece of paper, that is affixed to the instrument, and an endorsement can be contained in there. And there is case law saying that, discussing what it means to be affixed to an instrument. And there is no case law that I am aware of in the entire country saying that a paper clip is sufficient to affix an allonge to an instrument. If this court upholds the trial court's decision, you would be the first appellate court to do so that I'm aware of. I'd like to talk a little bit about the reason.
I'm sorry, when you say that there's no case law that you have found, and
Yes.
I'm assuming that you've looked.
I've looked.
Do you find anything that even addressed that issue?
Yes, I have, Your Honor. There's one case in Ohio in particular that's pertinent. It's HSBC Bank versus Thompson that is in our brief, and that's from the 2nd District in 2010. And they cited a Texas decision that had an extensive discussion of what it meant to affix. I will say a prior version of the UCC said firmly affixed. Now the UCC simply says affixed, but it still says affixed. And the Texas case that Thompson cited and discussed talked about the reason for the affixed requirement at all. It serves two purposes. The first is to prevent fraud, and the second is to preserve the chain of title. And looking at other means of affixing an allonge, some the courts have found were sufficient were tape, staples, glue, things like that. But the one thing I will comment about a paperclip is, unlike glue, staples, tape, it leaves no trace of its presence. It is much less firm or affixed than other means of attaching it. And that really raises the risk of fraud, that this document could slip away and that a borrower could have some confusion about who they had to pay the instrument back to.
Are there cases out there that say a paper clip, if you use a paper clip, it is not affixed?
Not that I'm aware of.
Okay. Nothing that says it is or it isn't?
There's nothing. So this new technology of the paperclip, you're going to be the first court to adjudicate this that I'm
Doesn't a
aware of.
paper clip leave an indentation? I mean, we've all seen that, haven't we? Where you
Rust marks.
Rust marks,
Well,
indentations.
I'll comment as well. Mr. Wheeler, the witness who authenticated the note, he viewed the note for the first time at the hearing. So when that paperclip appeared is anybody's guess. But we believe that that's not sufficient to affix the instrument. If I may reserve my last 2 minutes.
You may, you actually
Thank
have
you.
3.5 minutes.
Thank you.
Good morning. May it please the court, my name is David Wallace, and I'm here on behalf of the appellee Christiana Trust, a division of Wilhelmina Savings Fund Society, FSB, as trustee for Normandy Mortgage Loan Trust Series 2013-9. Diving directly into the first issue that has been raised on appeal, which is the issue of whether the trial court abused its discretion by admitting the loan documents into evidence below. The loan documents were properly authenticated. As the court knows, authentication merely means there's some evidence that indicates that the document that's being presented is what it purports to be. And the witness certainly testified to that. Ohio courts have recognized that in connection with business records, authentication kind of merges into the elements of the business records exception to the hearsay rule. And that's 8036. It's well established, and this district has also acknowledged that the elements for establishing the business records exception to the hearsay rule include that the record is one of a regularly recorded, it's a record that's regularly recorded as a regular part of the company's business. It's entered by a person with knowledge, recorded at or near the time of the event that's being recorded, and then there has to be foundation provided by a custodian or a qualified witness. Here we're talking about a qualified witness.
Did they have personal knowledge?
They did. The witness providing the foundation doesn't need to have firsthand knowledge of the transactions that are being testified about, and that's well established under Ohio law. And also in this district as well, in the Verona case that was cited in our brief and mentioned by the appellant's counsel, the witness has to be familiar with the operation of the business and the circumstances of the record's preparation, maintenance, and retrieval, and they need to be able to testify about that based on their knowledge that they have, that the record is what it purports to be, and that it was made in the ordinary course of business. And that's exactly what Mr. Wheeler testified below in the trial in this case. He testified that he was the case manager for Celine Finance, who was the servicer for Christiana. He testified he reviewed the documents and was familiar with the loan file of the documents. He testified he was familiar with Christiana Trust's record-keeping policies and procedures and practices. And he also testified that the business records of Christiana were indeed made at the time, or made at or near the time of the occurrence of the event that's being reported by persons with personal knowledge, and they're records that are kept in the ordinary course of business and created as a regular practice. So that establishes all the elements of the business records exception.
I think counsel indicated that on cross-examination, though. He indicated he did not have personal knowledge.
No, he had personal knowledge of Christiana's business records and practices. Now, the issue here is whether business records that were created by another entity that were incorporated into the current testifying entity's business records are also subject to the business records exception. That's the issue that they're trying to raise. But the admonition that the witness doesn't have to have firsthand knowledge of the transaction is equally applicable whether the witness is testifying about the testifying witness's businesses or prior businesses. And that's what's been described as what is known as some courts call the adoptive business records exception. Some courts call it.
Does the 9th District follow this?
What's that?
Does the 9th District follow the adoptive business record exception?
The 9th District has not directly determined that it does follow the adoptive business records exception. What the 9th District has said, though, is that it agrees that the testifying witness doesn't have to have firsthand knowledge of all the transactions, which is what the adoptive business records acknowledges. But as I said, the witness doesn't have to have that individual transactional knowledge, which is what the appellants are arguing needs to be had here. But under that adoptive business records exception, which is only a slight expansion of the business records exception in general, the witness doesn't have to have that personal knowledge of the exact circumstances of preparation and production. What the witness does have to have is knowledge that the records that he or she are testifying about were received and maintained and relied on in the ordinary course of business of the current entity, and that those records were actually incorporated into the testifying entity's records. And that's exactly what Mr. Wheeler testified to here. He testified that the prior records of the prior holders and the prior servicers, which would be Carrington and City Mortgage, were actually incorporated into Christiana's business records. He was able to review them when he reviewed the business records that related to the Barth loan. He also testified that the City Financial had merged into City Mortgage, so any records that might have been created under City Financial's watch became part of City Mortgages. And they then were, of course, incorporated into Christiana's. He also testified that, and it was apparent from the trial testimony, that Christiana relies on those records in terms of determining what is going to happen with a particular loan or what it's going to do, and that those records were incorporated into Christiana's records. Significantly, there was no testimony in the record that in any way suggested that any of those records were not trustworthy. Now, the adoptive business records exception, either by name or by actual decision, has been adopted by 8 of the courts of appeals that have really looked at the issue directly. And we cited the court to those cases in our brief, but I think it's important to note that the Greentree versus Roberts case out of the 12th, the Felty case out of the 1st, the Leonard case out of the 3rd, the Lawson case out of the 5th, the Busey case out of the 7th, the Zigden case out of the 8th, the Enders case out of the 10th, and the Christmas case out of the 2nd, have all acknowledged and accepted the rationale that underlies the adoptive business records exception and that underlies the legitimacy of what the trial court did in this case below. And again, these courts that I just mentioned, these districts have all acknowledged and recognized that there's a trustworthiness associated with these records because the company coming in has adopted those records as if they were their own, has relied on those records as if they were their own, and that provides the indicia of trustworthiness that allows the business records exception hearsay requirements to be accepted. And that's exactly what the court did here. The other thing that's important is that Mr. Wheeler also testified that there was a business relationship between the entities that are involved here. Carrington was the prior servicer. Salim took over the servicing after that on behalf of Christiana. Carrington continued as the master servicer, I believe Mr. Wheeler testified. And the point here is that it's pretty clear that these prior servicers had a business duty to record events that were occurred and keep those business records for themselves to make sure they're accurate. When those records were then incorporated in Celine's business records, that same business duty to do things correctly and get things accurate was imbued in there. So that's the whole purpose behind the business records exception. The idea, I mean, you know, we all know, I mean, the court is well aware that these exceptions, that this is all hearsay by definition. And these are exceptions to the hearsay rule. And there's what, I can't remember, 16, 18 of them? And the reason that the courts have recognized these exceptions is there's something about that particular type of evidence that has some trustworthiness associated with it. So, for example, business records, there's a trustworthiness associated with them because businesses rely on them. They incorporate them into their records. So there's a trustworthiness there. Look, this doesn't mean that the other side can come in and can't question the business records. That's not the case. Certainly witnesses can come in and say that record is incorrect, there's something wrong with that one, that sort of thing. But there wasn't any evidence like that in this case. And in fact, the only cases that have been cited by the other side are cases that are really distinguishable. The Babb case, I believe, involved records that involved letters that came from third parties that had no real reason to be truthful and accurate about what they were providing. The Royce case involved testing protocols that also were similarly not regularly conducted business activity that was routine. So those were different. There really aren't any cases that hold exactly what they're asking this court to hold here, that the records that are relied on and incorporated by one business when they take over business from another can't possibly be used. In fact, if the court adopts that rule, it's going to sort of eviscerate the business records exception, because then in order to prove up business records, you're going to have to go back to somebody 10 years ago that produced a business record that's just a regular routine type business record. Moving on to the second issue, the Ohio UCC only requires that the writing that's attached to a note be affixed. And the original note was in the courtroom. The trial court was able to look at it. They saw that the note was attached, the allonge was attached to the note by a paper clip. Attached is being affixed. There's no requirement under Ohio law that it be permanently affixed, which was sort of the argument in the brief, or firmly affixed, which I think was discussed at the trial court. There's no such requirement. And in fact, we cited a case in our brief, the TIC case, which actually did discuss the affixing of an allonge to a note by a paperclip. You know, one could argue as to whether the court ultimately came to the conclusion that the paperclip was actually affixed, or that was sufficient to affix it, because the court went on and said there was sufficient evidence in the record to establish the ability to enforce a note based on non-holder and possession status. So it's arguable that maybe the court didn't specifically hold it, but the important thing is the court acknowledged in the language, even if it was in dicta, that the affixing by a paperclip was sufficient. And in addition to that, it did cite another case, a federal case from another district, that had held that affixing by paperclip was sufficient, and also cited a commentator, a law professor who was an expert in UCC type issues, said that person felt that affixing by paperclip was sufficient as well. So for these reasons, we would respectfully request that the court affirm the judgment below. The trial court did not abuse its discretion based on this record in determining that there were sufficient indicia of trustworthiness as to the business records that were admitted into evidence here. There was no evidence to suggest that the documents and records were untrustworthy. In addition, the trial court did not make an error of law or fact in connection with determining that the note was enforceable, because the allonge, which was certainly tied to the note through loan numbers and that sort of thing, that it was affixed sufficiently to the note to provide the right of Christiana to enforce it and ultimately enter judgment on it. If there are any questions, I'd be happy to answer them, but otherwise we request the court to affirm the judgment.
Has this court rejected the adoptive business record exception in any of its previous decisions?
I'm not aware, I looked and I'm not aware of any specific rejection or general rejection of the adoptive business records exception by this court. I will note one thing as long as you ask it, Judge Teodosio, and that is the fact that a case from this court from a couple years ago, the West case, cited the 8036 standard and actually cited I believe it was the Roberts case, Greentree versus Roberts. And Greentree versus Roberts was that 12th district case I described earlier, in which the Roberts case specifically adopted the adoptive business records exception and found that the same type of testimony that was present in this case was sufficient to allow admission into evidence of the records here. And the fact that the West case from this district cited Roberts certainly suggests that the Roberts decision and the rationale is something that this court would adopt.
Thank
Your Honors, we've heard some policy arguments for why an adoptive business records exception should possibly exist, but in fact it doesn't. Every case cited that uses the shorthand term adoptive business records still includes the qualification that the rules of evidence are the rules of evidence, that any party that wants to try to use the so-called adoptive business records must still meet every requirement of 8036. And I don't believe there's a single authority that has ruled that any of those foundational requirements are excused by the fact that a business wants to rely on records produced by another business.
you. What do you say about the West case?
Which case?
The West case that was just referenced to us, which seems to support Greentree versus Roberts.
What I would suggest is these are all relatively new cases, and they are still interpreting 8036, which by its plain language refers to all shown as. I will acknowledge that many courts have conflated the authentication and personal knowledge requirements with the foundational requirements that must be shown to admit a business record. And I think it's not enough to simply say, I'm familiar with this record, I work at this business. The rule itself is quite specific that your familiarity has to be with the record-keeping practices. You have to have somebody who has personal knowledge enough to say, yes, I know City Mortgage. City Mortgage, when they keep records, they make them at or near the time by a person with knowledge. And this witness that they chose to use to meet their burden of production simply did not have that knowledge. I don't think that that is too much to ask as an evidentiary burden. Whenever you're pursuing somebody, in many cases, their most valuable asset, their family home. But even if there is a good policy argument for that, that is one that is best made to the drafters of the rules of evidence and not for the courts. The plain language of 8036 is very clear. Every foundational element must be shown by a witness with personal knowledge. And the Ohio Supreme Court has spoken on this repeatedly. The Ohio Supreme Court has not spoken on the so-called adopted business records exception and how far that would go. Are there no further questions?
So there's no conflicts out there between districts?
With respect to the adopted business records, probably, but I will say having practiced foreclosure defense for many years, this looks very much like the patterns of decisions that we saw before the Schwartzwald decision.
Thank you both for your presentations today. The court will take the matter under advisement. We will issue a written decision, which will be mailed to all sides, as well as posted on the Ohio Supreme Court website. Thank you.